Welcome to our deep dive into the UNCITRAL Model Law on Arbitration, a cornerstone in international commercial dispute resolution. Developed by the United Nations Commission on International Trade Law, this framework assists countries in modernizing and harmonizing their arbitration laws. It provides a comprehensive set of procedural rules for international commercial arbitration, aiming to ensure fairness, efficiency and consistency in the arbitration process. However, the model law has faced some criticism over the years. One common critique is the lack of specificity in certain areas, which can lead to inconsistencies in implementation. Critics argue that the broad framework leaves many details to be addressed by national laws or arbitration rules chosen by the parties. Another point of contention is the inadequate provisions for interim measures. Some believe the model law could offer more guidance on the enforcement of these measures and the role of courts. Additionally, while the model law emphasizes party autonomy, it sometimes imposes mandatory procedures that limit flexibility. This can undermine the ability of parties to tailor the arbitration process to their specific needs. The enforcement of arbitral awards also presents challenges, despite alignment with the New York Convention. Local enforcement issues may not be fully addressed by the model law alone. Critics also point out that national courts may still have too much influence over the arbitration process. This is particularly true in relation to setting aside awards or intervening in procedural matters. The model law's adaptation to technological changes is another area of concern. Initially drafted before the widespread adoption of digital technology, it may not adequately address issues related to electronic communication or online hearings. The complexity and accessibility of the model law can also be challenging for practitioners and parties not well versed in arbitration. This complexity may deter some parties from using arbitration or lead to misunderstandings about their rights and obligations. Finally, the model law might not fully accommodate cultural and regional differences in legal practices and arbitration traditions. A one-size-fits-all approach may not suit all jurisdictions equally. In summary, while the UNCITRAL model law has made significant strides in standardizing and improving arbitration practices worldwide, it is not without its criticisms. These issues highlight the need for ongoing adaptation and refinement of arbitration laws to address evolving needs and challenges in the field. National jurisdictions that adopt the model law often make modifications to address these concerns and better align with their local legal contexts.
Let's start by defining the guest list for this arbitration party, shall we? The UNCITRAL model law applies to international commercial arbitration, which essentially means disputes arising from business dealings between parties from different countries. Think of it as the United Nations of Contract Disagreements, bringing together parties from all corners of the globe. Now, you can't just have an arbitration without an agreement, can you? That would be like showing up to a party empty-handed. The model law requires a valid arbitration agreement, which acts as your invitation to this legal soiree. This agreement needs to be in writing, because let's face it, memories can be fuzzy, especially when millions of dollars are at stake. The model law also lays down the principle of separability. This means the arbitration agreement is treated as a separate entity from the main contract. So even if the main contract goes up in flames like a poorly wired toaster oven, the arbitration agreement survives. It's the legal equivalent of a cockroach, incredibly resilient and always there when you least expect it. This separation is crucial because it ensures that even if one party claims the main contract is invalid, you can still rely on the arbitration agreement to resolve the dispute. It's like having a backup generator for your legal case, just in case the main power goes out.
So, we've established that an arbitration agreement is your golden ticket to this international dispute resolution party. But what exactly constitutes a valid agreement? Well, the model law lays down some ground rules. First and foremost, the agreement needs to be in writing. Remember what we said about fuzzy memories? This isn't the time for a gentleman's agreement or a casual handshake deal. We need things documented, signed, and sealed tighter than a drum solo in a soundproof booth. Now, this written form doesn't have to be a formal contract with calligraphy and a wax seal. It can be as simple as an email exchange or a clause tucked away in a larger contract. The key is to have clear evidence that both parties consented to arbitration. Think of it as a prenuptial agreement for your business dealings. It's better to have it and not need it than to need it and find yourself in legal hot water. The model law also recognizes the validity of arbitration clauses incorporated by reference. This means you can have a separate document outlining the arbitration agreement and simply refer to it in your main contract. It's like leaving a treasure map in your contract, pointing to the hidden chest of arbitration rules. But here's the catch. The reference to the separate document needs to be clear and unambiguous. You can't just scribble a cryptic message in the margins and call it a day.
Now that you've got your arbitration agreement sorted, it's time to assemble your legal dream team, the Arbitration Tribunal. This isn't some ragtag group of lawyers who happen to share an elevator. This is a carefully selected panel of neutral third parties tasked with resolving your dispute. The model law gives parties the flexibility to decide on the number of arbitrators. You can have a sole arbitrator, acting as a kind of legal Superman, single-handedly deciding your fate. Or you can opt for a panel of 3, like a legal Cerberus, guarding the gates of justice with their multiple heads and legal expertise. The selection process is like a delicate dance, with each party typically nominating one arbitrator, and those 2 arbitrators then appointing a presiding arbitrator. It's like a legal blind date, where you hope the arbitrators you've chosen will hit it off and reach a fair decision. Of course, not everyone gets along famously, especially in the high-stakes world of international arbitration. The model law recognizes this and allows for challenges to arbitrators. If you believe an arbitrator is biased, lacks impartiality, or spends their weekends judging children's beauty pageants, a clear conflict of interest in our opinion, you can raise an objection. However, these challenges aren't just casual objections you can throw around like confetti. They need to be based on legitimate grounds, such as a prior relationship with one of the parties or a financial interest in the outcome of the case.
All right, we've got our players, we've got our playing field. It's time to talk about the rules of the game. The UNCITRAL model law is remarkably flexible for arbitration. It's like a choose-your-own-adventure book for dispute resolution. Party autonomy is a key principle. Parties have significant freedom to agree on procedures. It's like ordering a pizza. Choose your toppings and crust. Decide on language, applicable law, and seat of arbitration. However, this freedom isn't a free-for-all. The model law lays down fundamental principles. These include due process, equal treatment, and the right to be heard. The arbitral tribunal ensures these principles are respected.
Sometimes in the high-stakes world of international commerce, you can't wait for the final arbitration award to address an urgent issue. It's like realizing your roof is leaking during a rainstorm. You need to take immediate action to prevent further damage, even if it's just a temporary fix until the roofer arrives. That's where interim measures come in, acting as legal band-aids to address urgent situations while the arbitration is ongoing. These measures are temporary in nature, designed to preserve the status quo, prevent irreparable harm, or secure assets that might be at risk. The model law grants the arbitral tribunal the power to order a range of interim measures. These can include ordering a party to stop doing something like selling off disputed assets, or requiring them to take specific actions, like preserving evidence that might be relevant to the case. Think of it as a legal restraining order against a party that's about to do something rash. It's like saying, hold your horses, literally or metaphorically, until we can sort this out properly. Now, you might be wondering, what if the party ignores these interim measures? Do we send in a legal SWAT team? Well, not quite. The model law recognizes that enforcing interim measures can be tricky. After all, the tribunal doesn't have its own army of bailiffs. That's where national courts come in, playing a supporting role in this international legal drama.
After months, maybe even years of legal wrangling, witness testimonies, and enough document submissions to rival the Library of Congress, the moment of truth arrives, the arbitral award. This isn't just a suggestion or a friendly recommendation, it's a legally binding decision that puts an end to the dispute. The model law lays down specific requirements for these awards, ensuring they're more than just a strongly worded letter from a disgruntled judge. First and foremost, the award needs to be in writing, signed by the arbitrators, and include reasons for the decision. Think of it as a legal essay, meticulously outlining the arguments, the evidence, and the rationale behind the final verdict. The model law also requires the award to be notified to the parties. This isn't a time for cryptic messages slipped under the door or smoke signals sent by a carrier pigeon. The parties need to be formally informed of the decision, ensuring they're aware of their rights and obligations going forward. Now, you might be thinking, what if one party isn't too thrilled with the outcome? Can they just storm off in a huff and pretend it never happened? Well, not quite. The model law recognizes that while parties have agreed to arbitration, they might still try to wiggle out of an unfavorable decision. That's why the model law allows for a limited set of grounds for setting aside an award. These grounds are like exclusive VIP passes to a very exclusive legal club, and only a select few reasons will get you past the bouncer.
Congratulations! You've navigated international arbitration and have an arbitral award in hand. You might be tempted to frame it and bask in your legal triumph, but what good is an award if you can't enforce it? The UNCITRAL model. Law ensures your victory isn't just symbolic. It makes arbitral awards universally recognizable and enforceable. Think of it as a legal passport for your award. A global network of legal bounty hunters ensures compliance. The model law sets a streamlined process for recognition and enforcement.
Thanks for joining us on this exploration of the UNCITRAL model law on arbitration. We know it's a lot to digest, kind of like trying to eat a bowl of pasta with a spoon, messy, complicated, and you might end up with some sauce on your face. But hopefully we've demystified some of the jargon, shed light on the complexities, and shown you why this model law is so crucial in the world of international commerce. It's a framework that brings order to chaos, ensuring fairness, efficiency, and ultimately the peaceful resolution of cross-border disputes. So, the next time you find yourself staring down the barrel of an international commercial dispute, remember the UNCITRAL model law, your guide to navigating the labyrinth of international arbitration. Stay tuned for more insights into international law and dispute resolution.